Now, for your all-important ethics credit, I might add, is Miss Kendall Kelly Hayden to talk to us about ethics and professional responsibility. Kendall is the vice chair and office managing partner of Cozen O'Connor in the Dallas office. She actually grew up in Houston, but she resides in Dallas now. And she's been with Cozen for over 20 years. She focuses on hospitality and transportation law. She is a proud Texas Aggie.
Whoop.
Yeah. And since I went to Texas Tech, we will not hold that against her. But I will say that my basketball team did a little better than hers this year. Not quite as good as Kansas, but pretty good. But ladies and gentlemen, please welcome Kendall Kelly Hayden.
I look down at my phone because I understand that I'm the last presentation between you and the networking break. So I will promise to keep us on time. I wanted to say that not only do I really appreciate Stephen Barth and Taylor Wolchevak for always having me at this conference, but I think it's really important, since the next event is our networking 15-minute segment, to point out that I also really appreciate Elizabeth DeConti. And my first experience at the Hospitality Law Conference was 10 years ago in 2012. And I didn't even know there was such a lawyer as Elizabeth that had this very interesting presentation. And I approached her and I basically said, how can I become like you one day? And I think it's important that when we have these events, that it's not, I know a lot of us are here to market to clients and prospective clients, but it's wonderful to meet other people in the industry. And I'm so proud that I met her 10 years ago and that you're receiving that wonderful award today. So congratulations. Now, I will tell you that I like people to participate in my presentations because I talk a lot, and it is vastly more interesting if you also talk than listening to me speak for the next 24 minutes. So in order to bribe you to participate, lots of you have already been through these with me, I give away things. Now, normally I would walk through the audience and hand you something, but because we're on video, I can't do that. So I'm going to stand here behind the podium, and Taylor has volunteered to work with me as Vanna White to bring you something if you participate. I will tell you tomorrow I'm also presenting, and the items I'm going to give away tomorrow are not airplane friendly. So if you are traveling on an airplane, I suggest that you participate today. And if you are local, I suggest that you participate tomorrow. So the clicker, okay, here we go. All right, now let me just start out by saying I do not do any social media. So why am I talking about this? Well, because in our virtual world that we live in, and we're going to continue living in, there is a lot more social media interaction with lawyers and in our industry. And I tell you to take it personally because the statistics and the studies show that lawyers really like to intertwine both their personal and their professional lives on social media. So I want you to take away from this presentation, if you take nothing else away, that something you post personally can also subject you to ethical and disciplinary violations. So we're going to talk today about some of the technology and social media in the practice of law, some of the landmines that lawyers face in various situations, understanding the difference in virtual communications with parties, with other counsel, with the court, and with witnesses, including experts. And I always give a shout out to Stephen Barth. I'm going to talk about an ethical question for you when Stephen served as my expert witness, and when sanctions are and are not appropriate. Why am I talking about that? Because I keep seeing all of these motions for sanctions. Never in my entire career, which has lasted 20 years, have I had a motion for sanctions filed against any of my clients. Until last year, where one counsel, in a case where Stephen is my expert, filed 8 motions for sanctions against my client. And then because of course we're in Texas, we're going to talk about tales of the wild, wild west. And we're going to do some ABCs on best ethics practices. So here's your first opportunity to participate. 75% of law firms, when studied, use social media, and primarily, what do you think they use? Anybody can shout it out? Yes. LinkedIn, that's right. Okay, Starbucks card, middle table. What else do they use? You get a Starbucks card even if you're wrong. And so Instagram is not one of the more widely used ones, but that is okay. You still get a Starbucks card. Somebody said Twitter. Who said that? That's right. Okay, and you can also get more than one Starbucks card. And so we said Twitter, and I also heard LinkedIn. There's one more. Facebook. And guess what is the most widely, in this day and age, used avenue of social media for lawyers? No, it's actually Facebook. Can you believe that? I don't even know. I don't have a Facebook account. I don't want a Facebook account. I just learned how to use an emoji on LinkedIn. So I'm a little behind, and I'm okay with it. So what percentage of Texas lawyers belong to the Texas Lawyers Facebook group? Any ideas? 11%. You still get a prize. 11%, and it is characterized, it is the Texas Lawyers Facebook page, and it is characterized as the state's largest voluntary bar organization. How many states do you think have enacted some version of the ABA 2012 amendment that requires lawyers to maintain their competency by understanding technology? How many states do you think have adopted a rule discussing that? I'll tell you, over 40. So unfortunately, people like me cannot just put their head in the sand and say, well, I don't know how to do any social media, or I don't know technology, or I just learned how to use an emoji on LinkedIn, because it is a real thing and it is part of your evaluation in an ethical situation when your competency using technology is questioned. So let's look at some examples of social media landmines. Now, this was actually posted by somebody at CBS, not a lawyer. However, I share this with you because this is a personal statement that unfortunately can result in bad things happening. So what I have seen is that lawyers are either commenting on current events, they're either commenting on a case, or they're responding to a negative review online. So this is a lawyer responding to a negative review online, and I'll just let you read it, about his client. Now, the attorney's defense was, well, the representation concluded a year and a half ago, and her arrests, those were publicly available documents because they're court records, and so I didn't violate any attorney-client privilege. What do you think the review board did with that? Well, I'll tell you. Basically, he apologized for the post and later took it down, but the review board said it doesn't matter that something is a publicly available document. If it's not generally available or known to the community, then you are violating your ethical duty of confidentiality by posting that. So, negative reviews, be very careful if you decide to respond to those. So, under Rule 1.6, consider posting a general reply devoid of any confidential details, which simply invites the person to visit with you. So virtual communications with parties, with counsel, with witnesses and third parties, which would also include expert witnesses in my examples, and also with the court. So let me give you an example of a real case. This is a plaintiff's class action alleging non-payment of wages. The plaintiff's counsel called 12 potential plaintiffs trying to investigate the plaintiffs that might want to be part of the class, and sent cover letters along with a court-approved notice and consent forms. And they said, hey, this is the only way that we can find these people. So the defendants filed a motion for sanctions and also said they don't get an extension on the time that they need to get all the people in their class. So what do you think the court did with that? You think they denied the plaintiff's motion for the extension of time or granted it? The court denied it, said you don't have any more time, and the court granted the defendant sanctions, saying you violated the New York rules of professional responsibility by soliciting clients over the telephone. So one of the things that I did, and you'll see tomorrow when I speak, is I interviewed a lot of clients and my colleagues in the hospitality industry, and I said, what are you seeing in the hospitality industry? What are some of the trends that you're noticing? And this is out of the mouth of my client, who is a regional claims director for an international hotel. And he said, ever since the pandemic, people have been uncivil. And so I started researching this, because I can tell you that in this lawsuit I had with Dr. Barth as my expert, it was totally uncivil with these plaintiffs filing 8 motions for sanctions. And I started reading about it, and I was pleasantly surprised that one of my law partners actually wrote an entire article about the notion of civility. And so it's kind of a thing now. This is a hot topic in the ethics world for lawyers. And so basically, you can't get out of trouble by saying, well, they started it. So If there's a disparaging email, it does not necessarily have to be personal. It can be professional and vice versa for you to be sanctioned. So one of the examples I'll give you is that in Florida, one of the attorneys who had an opposing counsel who had a child with a birth defect was irritated about their inability to reach an agreement on a scheduling order. And so he talked about his son's birth defect in an email. And so the other lawyer also unfortunately acted unprofessionally and decided to call him inappropriate names and emails. They were both sanctioned. In Indiana, a lawyer took over the representation of a mother in a paternity action who was previously pro se, and then approached the opposing counsel and accused him of being fraudulent. He was also sanctioned. And the reason he accused him of being fraudulent was simply because he filed a motion to transfer venue. And finally, I'll share with you my personal experience, because if any of you have ever heard me speak, I always share my real life examples. So in my case that I told you about with the 8 motions for sanctions, one of my co-defendants who represented the house cleaning company for the hotel had to cancel a deposition because her uncle passed away the morning of the deposition. And these lawyers filed a motion for sanctions against her. Not very civil, if you ask me. So let me give you some hypotheticals, which are actually real cases. So if you actually know these cases, you should now participate. Is it sanctionable in Texas for an attorney to hire a third party to conduct a poll about their client to determine whether there are any biases towards his client? And when I say a poll, I mean witnesses in the case were contacted, some of the parties. Does anybody know about that case? And if you don't, that's okay. But if you want to opine, does anybody have an idea whether that is a sanctionable action? Yes.
It's just discovery in the sense of tell me what your thoughts are. It's like a mock trial, maybe.
And that is such a good lawyerly answer. And what's great about it is that you are correct. The trial court in Texas found that it was sanctionable, and the Texas Supreme Court said he was actually acting in good faith. And so absent some showing that the attorney was acting in bad faith or doing something impermissible and not really doing his job. I mean, he was really trying to figure out whether there was a bias towards his client. So the Texas Supreme Court came back and said the sanctions were not appropriate. Is it sanctionable in Connecticut for an attorney to send a friend request to opposing counsel's wife after the judgment to determine whether the husband, who was the defendant, was transferring assets to his wife in an attempt to remain judgment proof? This is a real case. And it's kind of a mouthful, so I'll just tell you the answer. The answer is that he was not supposed to contact the wife without explaining that he was the attorney for the plaintiff. He did not disclose that. He knew she was unrepresented because the defendant had multiple times, the defendant's counsel had said, she's not represented by us. But ultimately the court said she didn't accept the friend request, so no harm, not sanctioned. However, he was reprimanded, although there was no sanction issued, for not being, for making a false statement or misrepresenting who he was actually associated with. Now we get to talk about experts, real world examples. So I'm prepping my expert witness. This is not Dr. Barth, by the way. And so it's a construction case. And he says to me, who is my client? It's the insurance company, right? And this is an insurance defense case. It's a construction defect lawsuit. And I said, no, I understand they're paying your bills, but you need to understand that your client is also my client. We represent the same, we're here for the same party. And so I thought it was interesting that my own expert, who's very smart, who went to Rice, did not actually know who his client was. He then asked me, we're on Zoom doing this prep and the deposition was going to be via Zoom. He asked me, is it okay if I talk too much if you just kind of flip your hair? And first of all, no, that's not okay, because when you're doing a deposition or anything via Zoom, it's just like you were in a conference room, just like I can't turn around and step on your toe if you're talking too much. I can't flip my hair. And by the way, I get it blown out once a week, so I wouldn't flip it anyway. Do you believe it's a conflict of interest for you to serve as an expert and the contractor? This is in the same construction case. So the plaintiff's expert for the electrical defects or alleged electrical defects is also the contractor bidding the job at this particular senior living facility here in Houston. He's the contractor bidding the job to do all the repairs, and he's also serving as the expert. Does anybody have an issue with that? I have an issue with it. He's making a lot of money, I can tell you that. Okay, Dr. Barth. So this is an issue that I actually had to research because I didn't know the answer. And I will tell you that we all know that he is on the up and up and he would never be in an ethical situation. So I'm giving you the advanced answer that there's no issue with this. But I learned that when I retained Dr. Barth to be my hotel expert in my case with the 8 motions for sanctions, it was a security case where a hotel room was burglarized. He was my duty of care expert on the security side. And at the same time, he was the plaintiff's expert, or is still the plaintiff's expert, in a dram shop case for a restaurant. And these cases are both being handled by my firm, and he's the expert for the plaintiff in the restaurant case and the expert for the defendant, who is my client in the hotel case. So does anybody see any issue with that at all?
Glad I got my hair cut, but other than that.
So the answer is no, because they're totally separate issues. Obviously, one has to do with dram shop issues, one has to do with hotel security. But I think it's important to be prepared for questions like that if somebody does their research and figures out that he's an expert adverse to my client in one case and an expert for my client in a different case.
Kendall, we got a quick question.
Oh, yes.
Was this the same client?
No. Sorry, I should have said that.
Yeah.
Thank
that
you.
was my question.
Restaurant client versus hotel client, 2 different companies. Both Texas cases, one pending in Galveston, one pending in Dallas.
Yeah, Jacob, you can't ask questions where I'm involved. Sorry.
But it's so
Good
fun.
question. Yeah.
Okay, so this is a real world story. So a labor and employment attorney in New York, and by the way, except for Dr. Barth, I always remove people's names because I think it's respectful. This is a lawyer who was local counsel in a wage and hour case for some plaintiffs. And again, it's a class action situation where she needed time to collect her plaintiffs. And so on November 23rd, 2016, that was the deadline to file a motion for the conditional certification of a class. On December the 9th, 16 days after the motion was due, she filed her motion along with a request for an extension of time. And in the motion, it said that she had an unexpected trip to deal with a family emergency when in fact she was on vacation and was dumb enough to post on Instagram that she was on vacation. Does anybody want to guess what the sanctions were? $10,000. So one of the things that I think is interesting, and there are articles about this, I don't like to read slides, but basically the gist of this case is that a judge in Pennsylvania said the client has to pay the sanctions, not the attorney. So my question for the group is, does anybody feel strongly about whether when there are sanctions awarded, is it the party that should pay? If you have a choice, obviously in this case, there's no choice. The judge said the client's paying, not the lawyer. Does anybody have a strong feeling as to whether the lawyer should pay or the lawyer's firm, or whether it's the client that should pay? Or is it fact dependent? Well, I will tell you, it's in my opinion, and in
Kendall, I'm sorry,
Oh,
we
I'm
got
sorry.
somebody over here that has a thought.
didn't
Hold
s-
on one second. The judge, hold on, this ought to be good.
Oh God, I'm nervous.
Given that it was the lawyer who misrepresented the facts, it seems very unfair that the client should pay.
And you know what? I agree with you. In my case that I told you about with my 8 motions for sanctions, one of the motions for sanctions was literally because they alleged that we were delayed in supplementing a verification to an interrogatory. For those of you not from Texas, it's basically a notarized, it's not even really notarized, it's just a signature page saying, yeah, I wrote these answers and they're correct. And they filed a motion for sanctions against us saying that we didn't timely supplement the verification, and it was granted. And to your point, I blamed myself and my law firm for not timely supplementing that. It was not my client's fault. And so I told my firm, we have to pay this sanction. Now, in other situations, you may not have the choice. And that's why I bring this case up. Oh, I don't think I clicked it. Okay, the Wild Wild West, here we go. Who knows a fun fact about Sam Houston? Since we're in Houston, if you don't know who Sam Houston is, on the side of I-45, it's a really tall white statue. He is the only person to be governor of 2 states, Texas and Tennessee. And of course, I have him up there because my husband and son are both named Houston because they are related to Sam Houston. Now, the Wild Wild West of Texas, I just have to share with you over the last 2 years some of the sanctions that have been awarded to my fellow Texans. Okay. Now, This was a post from somebody in a well-known international firm based in Dallas who was not a lawyer, document services manager, in response to a retail establishment's requirement that he wear a mask. I'm sorry to say, but I feel like sometimes these things only happen in our state. So that was what he posted. The law firm promptly terminated him and posted a release saying this completely goes against the values of our firm. So I share this with you because it was not a lawyer that posted this, but you can still be on the hook when your staff or anybody else at your firm who you may or may not have a duty to supervise and monitor is posting that. Okay, so these are just some examples. Unfortunately, they're all judges that were sanctioned, and there are various counties, and lots of them involve brandishing a shotgun. And so again, these are mostly personal situations. But again, you can be sanctioned for that even if you're not doing it in a professional setting. My favorite is the last one where the judge denied that he got into a tirade with a criminal defendant and the defense attorney, and then he blamed it. He later admitted that he got into the tirade, but he blamed it on his blood sugar. It kind of reminds me of my fellow coworker who does not work at my firm anymore, who told everybody that she would get into anaphylactic shock if she smelled popcorn. So there were signs all over the office saying, do not pop popcorn in this microwave. And one day, indeed, somebody who was new did pop popcorn, and she went on a tirade with a bunch of curse words very loudly we were having a mediation in our firm. And the next day she denied, she totally forgot that she did that. So nobody was sanctioned. I just shared that with you as a funny story. Okay, so I did some ABCs for you. Don't worry, I didn't go to Z because I knew you would get bored. But let's just talk about some of the best ethics practice for counsel. Now, who in this room, I hope I have some Starbucks cards left, who knows what that is? And who said outhouse? Yes. So my family is from the country, Southeast Texas. Actually, that was painted by my grandmother, who was 102 when she died last year. And then that is actually her mother's outhouse. So I share this with you because when I talk about ethics, and I'm just looking at my time here, I want to make sure everybody understands that it applies both to in-house counsel, and I'm going to call us panel counsel, outhouse counsel. So basically the rules are the same, okay? And it's much more fun than saying panel counsel. But just so you know, there's only really one carve-out difference between in-house counsel and outhouse counsel in terms of ethics, which I will talk about. But generally speaking, the standards are the same. So you can't say you're in-house counsel and therefore the ethical rules don't apply to you. And I share that, not because I think anybody in this room would do that, but as you will see, some other in-house counsel have actually made that claim. With attorney-client privilege, there's an astounding number of people that think attorney-client privilege communications are confidential communications, and that's it. And I'm here to tell you, I'm sure all of you know this, there's actually 4 requirements, okay? There's got to be a communication. There's got to be a lawyer talking to a client, and there's got to be a request for or offering legal advice, and it has to be confidential. So you don't just get to cloak something in the attorney-client privilege if it is a confidential communication. So for example, if you're the CEO or you're an in-house counsel in this room and you're talking to somebody, say your CFO, about a piece of business advice, that is not considered attorney-client privileged because it's business advice, not legal advice. It doesn't mean it's not confidential, but you have to make sure that that distinction is made. B is for business transaction. So basically, this is the focus on in-house counsel that is more susceptible. It's easier for in-house counsel to engage in business transactions with their company. It's a little bit, it's not that we can't do it as outhouse counsel, but it's just a little different, excuse me. So just be aware that, you know, if there is a business transaction and if it is not properly complied with under Rule 1 of the Model Rules of Professional Conduct, then you can be sanctioned for that. C is for competence. As I stated when I first started talking, competence now includes the duty to understand technology. So malpractice claims against lawyers are on the rise because of this, and you cannot just simply say, I don't understand. Actually, a lot of the articles talk about the fact that if you don't understand how to use technology, then you need to outsource that and make sure that you do understand how to use it. D is for delegate. Just because you delegate something, you outsource it to another company, does not mean that the rules do not apply to you. So in our document services case where the guy posted the anti-mask rant, he was not a lawyer. The rules still applied to the law firm. I don't really need to say any more about that slide. Everybody in this room knows that. Okay, F is for false. This is my example of the lawyer who communicated with the defendant's wife asking for information about assets. He did not disclose who he represented. Ultimately was not sanctioned, but the court still found that he was engaging in a false statement because he was not disclosing that he was representing the plaintiff's counsel. G is for general. Remember, if you're going to comment on a review of you, make sure that it is general and devoid of any confidential information and that you're not slandering your clients. H is for hats. This lovely lady with me is wearing a beautiful flower hat. She's also sitting at this table over here. That's Christine Johnson. Christine Johnson's not only the general counsel of La Madeleine and La Deaf America, but she's also the secretary and most recently the chief operating officer. So I bring that to your attention to let you know that when people wear more hats, for example, I wear another hat in my firm. I translate documents into Spanish and from Spanish into English. But just because I'm translating something does not mean that my ethical duties as a lawyer go out the window. Similarly, speaking to in-house people that have multiple hats, your ethical duties remain the same, even if you are, for example, using an activity or engaging in something as the secretary of the company. I is for investigate. I will tell you that there is such a thing as the duty to Google. And in my case, which I keep referring to with my 8 motions for sanctions, these guys filed a motion to de-designate a responsible third party in my case. And the responsible third party was the criminal defendant who had burglarized the hotel room at our hotel. And their basis for filing the motion to de-designate, and I cannot make this up, was in our discovery responses. In Texas, we call them responses to requests for disclosure. We did not supplement with his address. And so that was the basis of their motion to de-designate the criminal defendant. And the court looked at him on the stand, took out our computer, Googled the criminal defendant, and said, guess what, counsel? He's in jail. Here's your address. So you do have a duty to do some investigating. What was interesting about that case is that this lawyer that filed this motion to de-designate the responsible third party, he didn't have the address in his discovery either. Okay, J is for jail. As you saw in my Wild Wild West part of the presentation, it is not just for criminal defendants. You too, as a civil lawyer, can be sanctioned and also can go to jail, like the judge who brandished her shotgun at her ex-husband's girlfriend. K is for Kendall. Just kidding. Know who your client is. Not everybody who works at the same company as the in-house attorney is the client. So the general rule is that it needs to be somebody communicating with the in-house attorney who can bind the company, or somebody who regularly communicates with the attorney and seeks legal advice. So make sure that people that are working with you, if you are in-house, understand when the privilege applies and when it does not, and when there's protections and when there is not. L is for legal issues of the company, not the individual. What I mean by that is that the in-house counsel is not supposed to be giving advice to employees on what they should do with their stock, or should not be thinking about their own stock and what their stock might do and giving advice to the company, as opposed to thinking about what is best for the company. So the other interesting fact is that as an outhouse lawyer, I have to do the same thing. So when I'm hired to represent the Ritz-Carlton in Dallas, I have to explain to all those employees, I am not your lawyer. And so you cannot be coming to ask me employment advice because you're unhappy with something when I was hired to represent the company. So it applies not only to in-house attorneys, but those of us who are outhouse lawyers too. M is for misconduct must be reported under the right circumstances. You must report to a higher authority if there are actions of officers or directors or other lawyers in your firm who may be engaging in misconduct. Uncomfortable, but just something to remember. And finally, N is for not in the office. I did not want to bore you with the discussion of the unauthorized practice of law, because that was the legal writing memo in my first year legal writing class at SMU Law School. So if I never have to talk about the unauthorized practice of law again, I'll be fine. But I think it's important for those of us to know that it's a thing now because of where people are working. And so there's a whole host of opinions that discuss, well, if you're licensed in Texas, but you're working in Florida, are you supposed to be giving advice under Florida law if really your license is only in Texas? So that it could be an entire presentation all on its own. But I encourage you to be mindful of that, because I think you're going to see a lot of developments in this area of the law as we continue to be in this virtual world. So I'm at 27 minutes, so I'm going to stop now. Thank you.
Thank you very much, Kendall. That was great.